At 6:47 a.m. Eastern Time this morning, the machinery of the United States Supreme Court ground to a halt on the issue of presidential immunity in civil cases, and in doing so, it effectively dismantled the legal shield that has protected Donald Trump for nearly 2 years. Federal docket number 24871 was updated with a summary denial. There was no sweeping opinion, no dissenting essay from a sympathetic justice, and no oral argument scheduled for next term. There were just 4 words: petition for writ of certiorari is denied, that collapsed the entire delay strategy of the president's legal team. But if the Supreme Court's silence was a thunderclap, what happened 3 hours later was an earthquake. At 2:34 p.m., a new filing appeared in the same docket, submitted not by the president's white shoe law firm, but by independent counsel retained by Melania Trump. This document has stunned every constitutional scholar and legal analyst who has reviewed it in the last 6 hours because it is not a defense motion. It is, for all intents and purposes, a declaration of legal independence. It is a wife severing her liability from her husband's conduct in open federal court while he sits in the Oval Office. If you are trying to understand the gravity of this moment, you have to look past the headlines and into the granular details of the legal text, because what is happening here is a simultaneous collapse of the political, legal, and personal firewalls that surround the presidency. This is not just a bad news cycle. This is the beginning of a constitutional stress test that the system may not have seen since 1974. Let's start with the Supreme Court. To understand why this morning's denial is so catastrophic for Trump, you have to understand the strategy his team has been employing. For 18 months, the goal has not necessarily been to win the case on the merits. The goal has been to delay it until he is out of office or until the political landscape shifts. They have filed motion after motion, appealing to the D.C. Circuit, requesting emergency stays, and petitioning the highest court in the land, all based on the theory that a sitting president should be immune from civil discovery. They knew the odds were long. The Supreme Court grants review to fewer than 100 of the 7,000 petitions it receives annually, a roughly 1.4% acceptance rate. But they filed anyway because filing stops the clock. At 6:47 a.m., the clock started running again. By issuing a summary denial, the Supreme Court didn't just say no. They said the argument was so constitutionally weak that it did not even merit a discussion. They let the lower court's ruling stand, which means the legal reality now reverts to the precedent set in Clinton versus Jones in 1997. A sitting president is not immune from civil litigation for acts unrelated to his official duties. The delay is over. The case returns to the district court immediately. And this is where the specific nature of this lawsuit becomes the nightmare scenario for the White House. This is George Will versus Donald Trump. It is a civil suit alleging defamation and interference with damages totaling $47 million. Because it is civil, the pardon power, the ultimate trump card of the executive branch, is utterly useless. A president can pardon a federal crime. He cannot pardon a civil judgment. He cannot sign an executive order to wipe away a debt owed to a private citizen. If he loses this case, he owes the money. If he refuses to pay, his assets can be seized. But the financial threat pales in comparison to the procedural threat. With the immunity claim dead, the case moves to the discovery phase. And discovery means one thing above all else: depositions. Donald Trump is now facing a deadline of March 15, 2026 for the close of discovery. That means within the next 90 days, the President of the United States will likely be compelled to sit in a conference room under oath with a camera rolling and answer questions from George Will's attorneys. Imagine the scene. This isn't a press conference where he can shout fake news and walk away. This isn't a debate where he can interrupt. This is a legal proceeding where every evasion is a potential sanction and every lie is perjury. He will be asked about his finances. He will be asked about his communications. He will be asked to explain under penalty of law the actions that led to this lawsuit. And unlike Bill Clinton, who complied with the court's order to testify in the Paula Jones case, Donald Trump has a history of defying legal norms. If he refuses to sit for this deposition, we enter uncharted waters, a judge holding a sitting president in contempt of court. It is against this backdrop of looming legal catastrophe that Melania Trump's filing must be viewed. At 2:34 p.m., her attorneys submitted a document that effectively threw the president to the wolves. The language is precise, cold, and devastating. The filing filing asserts that her legal interests are distinct from and not in alignment with her husband's. But the nuclear bomb in the text is the explicit confirmation that no joint defense agreement exists or is contemplated. To a layperson, that might sound like legal jargon. To a lawyer, it is a siren. A joint defense agreement, or JDA, is standard operating procedure for any couple or group of defendants facing liability together. It allows them to share information, coordinate strategies, and maintain privilege over their conversations. It is the shield that keeps the team united. By stating on the record that no JDA exists, Melania Trump is publicly announcing that she is not on the team. She is not sharing information with the White House. She is not coordinating her testimony to match his. She is operating as a free agent. This destroys the historical precedent of the first couple defense. When the Clintons were under siege during Whitewater, they moved as a phalanx. When the Kennedys faced scrutiny, the family closed ranks. Melania Trump has done the opposite. She has built a legal firewall. She is arguing that her assets, her liability, and her future are separate from his. She is asking the court to treat her not as the president's wife, but as a distinct legal entity who should not be dragged down by his conduct. The implications of this are terrifying for the president's legal team. If Melania is deposed and without a JDA or spousal privilege over non-confidential communications, she absolutely could be. She becomes a witness, not a hostile witness necessarily, but a fact witness whose primary loyalty is to her own legal protection. Imagine a deposition where the First Lady is asked about the president's business dealings or his state of mind, and her lawyer, who is not a White House lawyer, advises her to answer fully to avoid her own perjury trap. It opens a vein of vulnerability that the president cannot close. We are also seeing the financial subtext here. The filing mentions asset consideration. This suggests that Melania is moving to ring-fence her own property and finances from the $47 million judgment that George Will is seeking. It reads, as one constitutional scholar noted, like a prenuptial agreement being litigated in real time. She is ensuring that if the ship goes down, her lifeboat is already in the water and untethered. This legal estrangement has triggered a shockwave in the political arena that is moving faster than anyone anticipated. The Republican establishment, famously disciplined in its defense of the president, is fracturing. The catalyst was an op-ed published last night by George Will himself. The headline was a manifesto. No one is above the law, not even in marriage. George Will is not a liberal provocateur. He is the dean of conservative intellectuals, a man who has defined the movement for decades. When he frames Melania's filing not as a private marital dispute, but as a constitutional crisis of confidence, he is giving permission to other conservatives to break ranks. He is arguing that if the president's own wife will not defend his legal position, why should the Republican Party? And the cracks are showing. In the 72 hours since the filing became public, 17 prominent Republicans have issued statements that essentially abandon the president on this issue. Senators like John Cornyn of Texas, deep red establishment figures, are saying things like civil liability is not partisan, it is constitutional. That is code. That is a polite way of saying you are on your own. Even more deafening is the silence from the leadership. Mitch McConnell hasn't said a word. Kevin McCarthy is invisible. Mike Johnson offered a 12-second soundbite that amounted to no comment. In Washington, silence is an action. It is a calculation. It reminds historians of the summer of 1974 when Republican leaders slowly stopped defending Richard Nixon, not with a bang, but with a quiet retreat. They are reading the polls. They are looking at the legal reality. And they are deciding that the political cost of defending a president who is losing in the Supreme Court and losing in his own home is simply too high. So where does this leave us? We are staring down the barrel of a 90-day window that will define the future of the presidency. The case is returned to the district court. The discovery clock is ticking. Donald Trump has 45 days to respond to the latest motions. By April or May, the deposition window will open. The president has three options, and they are all catastrophic. Option one, he complies. He sits for the deposition. He raises his right hand. He faces George Will's attorneys. In this scenario, he risks everything. His finances are exposed. His past statements are cross-referenced with hard data. Every contradiction becomes a perjury trap. Every admission becomes fodder for the other 12 civil lawsuits currently pending against him. It is a minefield that no lawyer would ever want their client to walk through, let alone a client with a history of being loose with the facts. Option two, he refuses. He claims executive privilege or simply ignores the subpoena. This precipitates a constitutional crisis. The judge would likely hold him in contempt. We would then face the spectacle of a court levying fines against the president or potentially issuing a bench warrant. While the optics of arresting a sitting president are nearly inconceivable, the legal stain of being in contempt of court would cripple his administration and provide ammunition for impeachment proceedings. It would act as an accelerant to the political fire George Will has already started. Option three, the nuclear option. This is the scenario that is being whispered about in legal circles. His team could attempt to construct a novel legal argument, perhaps claiming that the specific information requested is classified or protected by national security interests, thereby trying to move the case out of the civil arena and into the secretive world of the national security courts. But this is a Hail Mary. It requires a level of judicial deference that the Supreme Court just explicitly refused to grant him. What makes this moment so singular is the isolation. When presidents get in trouble, they rely on three circles of protection: the courts, their party, and their family. In the span of 24 hours, the courts have said no, the family has filed for separate counsel, and the party has gone silent. The pillars are crumbling. We are watching a systemic stress test. Can the presidency function when the occupant is fighting a multi-front legal war without allies? Can the executive branch operate when the First Lady is legally walling herself off from the chief executive? These are not theoretical questions anymore. They are being litigated on docket 24-871. This story is moving faster than the mainstream media can process because it doesn't fit the usual partisan boxes. It isn't Democrats versus Republicans. It is the rule of law versus Donald Trump. It is Melania versus Donald. It is the Supreme Court versus the executive. The illusion of invincibility that has surrounded this presidency is evaporating. The delays are over. The unity is gone. And as the discovery deadline of March 15th approaches, the reality is setting in. There is no one left to blame, no one left to hide behind, and no court left to appeal to. The president is standing alone in the well of the court, and the whole world is watching to see if he blinks. This is a developing situation of the highest magnitude. We will be monitoring the docket every single hour. We will be tracking the movements of the independent counsel, and we will be watching the Senate floor to see who breaks the silence next. Stay tuned, because the next domino to fall won't just shake the news cycle. It could reshape the republic.